When you're dealing with the death of a close friend or family member, a complicated legal process is the last thing that you want. The Florida small estate affidavit process can make at least one aspect of death easier to deal with: distributing property. We're eForms, the largest online database of fillable legal forms, and in this video, we'll address Florida's small estate affidavits, including how small estate affidavits work, the different types available in Florida, and the filing process. Be sure to watch through to the end of this video to find a link to an approved small estate affidavit that you can use to get the property you deserve. First, how do small estate affidavits work? In estate law, a person died is known as a decedent. The decedent's property is called an estate. If the decedent had a will, the people who receive pieces of the estate are called beneficiaries. Decedents without a will are said to be intestate, and the people who receive the estate under the Florida rules of intestate succession are called heirs. The legal process of passing the decedent's estate on to other people is called probate. Probate can be a long and complicated process, particularly for large estates, but for those with fewer assets, it's usually not necessary to go through it. Small estate affidavits are a way around the probate process, giving title to heirs or beneficiaries. What kind of small estate affidavits does Florida have? Unlike most states, which just have one option for small estate affidavits, Florida has two processes: summary administration and disposition of personal property without administration. Summary administration still requires going through a probate-like process, but is typically much faster. It's only available for estates with a total value of less than $75,000 with debts and liens not included. Unlike many states, Florida does allow estates that include land to go through this process. Disposition of personal property is typically even faster, but is more limited. It can only be used to transfer personal property, and only when the personal property is being used to cover expenses associated with the death of the decedent, such as a funeral or medical expense. If you're going to pursue summary administration, you should make a list of all of the decedent's assets and get in touch with everyone who is named on the decedent's will. If the decedent died intestate, get in touch with surviving spouses, children, and other relatives. Finally, before filing the petition, you have to notify any creditors to whom the decedent may have owed money. Florida has some pretty strict rules in this regard. Along with seeking them out, you'll need to publish a notice in the newspaper alerting potential creditors. Once the notice has run for 2 weeks, contact the local circuit court for the county where the decedent lived to file a petition. If you're going to pursue disposition of personal property, along with creating a list of the decedent's assets, you'll need to create a list of expenses that were incurred as a result of the decedent's death. You'll need copies of these bills as well as a certified copy of the decedent's death certificate. The bills can be outstanding, or if someone has already paid them out of their own pocket, then the process can be used to seek reimbursement. Finally, you'll need to be able to demonstrate that the value of the decedent's assets are less than or equal to the value of these bills. Then you can file the form with the circuit court for the county where the decedent lived. Click here to obtain an approved Florida small estate affidavit for the disposition of personal property process. And don't forget to hit that subscribe button to find more eForms videos on legal issues that impact your everyday life.